of the Crystal Big podcast. Today, we are still dealing with the issue of the political and legal crisis in Rivers State. And of course, we are going to be having some learned friends of ours who are going to be discussing the matter. Now, I'll give you a rundown of the background of the issue we are going to discuss today. On the 10th of February 2025, the Supreme Court assented to the request of the councils to Governor Fubara to withdraw his appeal against the judgments of Justice Kayode J. Omotosho of the Federal High Court, Abuja, delivered on January 22, 2024, and the Court of Appeal judgment of Justice Olubunmi K. Oyenile, Justice Okon Efre Abang, and Justice Ishaq Mohammed Sam, delivered on Thursday, the 10th of October 2024, in appeal number CA-ABJ-CV 133-2024, between the Governor of Rivers State as appellant and the Rivers State House of Assembly, Martin Amehule, the Honorable Speaker, Rivers State House of Assembly, the National Assembly, Caucus of Rivers State, and the entire leadership of the National Assembly. Of course, and then including the Attorney General of Rivers State Civil Service, Inspector General of Police, and Right Honorable Ogerenye Edison, who also was addressed as the Speaker. These were the defendants. When the matter was ripe for judgment or maybe ruling, Counsel for Governor Fubara applied to withdraw his appeal against the entire judgment of the appeal court on the grounds that it's been overtaken by events. That to many was strange. Strange in the sense that there was no specific mention of the issues that were affected by whatever events. Some say it was the issue of the 2024 budget, which the court had ruled against the governor and even ordered him to present the budget to Martin Amehule-led assembly. The Court of Appeal upheld it and even condemned the governor's actions in presenting the budget to a four-man assembly. Those on the side of the governor say it was a technical withdrawal to avert an outright pronouncement or a death knell by the Supreme Court, particularly with regards to the issue of leadership of the House under Amehule. But those on the side of the 27 lawmakers, led by Martin Amehule, that having withdrawn the appeal against a full judgment that is not limited to only the issue of the budget 2024. As such, the judgment of the Federal High Court, upheld by the Court of Appeal, stands. While both sides have laid claim to victory over the Supreme Court ruling, another suit filed by three lawmakers, Honorable Victor Okojombo Boni, that's representing Boni constituency, state constituency, Honorable Sokari Goodboy, representing Ahodo West State constituency, and Honorable Adolphus Orubiye Nimiga, representing Opobo Nkoro State constituency, against Martin Amehule and 26 others over the legitimacy of their membership of the House having defected or purportedly defecting from the PDP that sponsored them to the APC. The matter, which came before Justice Emmanuel Obele of the Federal High Court, Port Harcourt, on Monday, February 17, 2025, was adjourned to April 30, 2025, after the court was informed by counsels for the defendants that the Supreme Court was sitting on some matters that may be similar and had reserved judgment for a date to be communicated to parties. Today, in this episode, we have two fairly lawyers to do justice to the issues arising from the decision of Justice Obele to adjourn the matter. Well, while we are still expecting one of them to be here, I have with me in the studio Barrister Sogbeye Eli, lawyer, politician, and public affairs analyst. And of course, we're still expecting Barrister Gospower Ebule. Both of them are legal practitioners and who are based in Rivers State and have a good knowledge of the political crisis, which has been trending in the media since the bombing of Rivers State House of Assembly on October 30th, 2023. You are welcome to the program, sir.
Thank you for having me. Good afternoon, Port Harcourt.
Viewers, we promise you another moment of incisive and informative discussion. Please don't go away. Remember to follow us on YouTube and other social media handles. Subscribe, and so you can also get updates. Thank you. So, Mr. Sogbeye, what do you make out of the decision of Justice Emmanuel Obele in adjourning the matter, based on the fact that, or on the claims by the counsels to the defendants, that there are similar matters before the Supreme Court? I was thinking that these matters are not the same, or are they similar?
Well, the practice of our law is circumscribed by rules of courts, apart from the Constitution.
Okay.
And the hierarchy of courts. If a matter is for a trial court, in this case a federal high court,
Okay.
and counsel on the other side bring to the notice of the court that the parties before you are already before the Supreme Court on similar issues,
Okay.
and therefore the Supreme Court is already seized of jurisdiction. The wise thing to do for any judge in the shoes of Justice Obele is to defer to a superior court, whether this be the appeal court or Supreme Court. Moreover, when he said that the matter before Supreme Court was adjourned reserved for judgment, many issues have been joined, and the matter has become a far-reaching thing that could have consequences. Those consequences could be detrimental to the suit before the Lord, the Honorable Justice Emmanuel Obele.
Okay.
And so it's only common sense that the judge will not want to be overreaching himself. All right, so that it does not look like what he has before him is what might force a fait accompli.
Okay.
So nobody's going to die. Standing down to allow the Supreme Court to ventilate on issues, because of course, at the root of all of this is the principle of natural justice,
Okay.
which is to hear the other party. So if a party comes forward and says, "My Lord, we may not be able to go ahead because we're already at the Supreme Court," it's only natural to allow fair hearing happen, so that you don't proceed and then tomorrow it looks like we shouted that we're already there, he didn't listen to us.
Okay.
People might even accuse the judge of having a vested interest. So it is safe to say that when parties are before a court and they bring to the notice of a judge that what is before him, my Lord, is already before a court of a higher jurisdiction, it's a practice, in a normal practice, a judge would step down.
So it's safe to say that the suit filed by those three lawmakers are similar to the appeals before the pending before the Supreme Court, for which parties are expecting a date for judgment.
Well, I wouldn't say it's at least same. I wasn't in court. I wasn't in court before Justice Obele, but my thinking and what I gave is a broad view
Okay.
of what looks like a canvas of our practice. Parties before a court will determine what jurisdiction a court can have.
Okay.
What are the issues for determination? What's the subject matter for determination? Those things inform the court's approach, what they call lax jurisdiction or has jurisdiction. So if on the one side they find Ameul on one side and it's other people, on the other side Aboko Jumbo on the other side, they are same things.
Okay.
Don't forget that the contention about what's going on here is that the House of Assembly was probably constituted until that crisis blew. Okay. Now, some people haven't moved out of the APC, of the PDP to the APC. That issue had not been resolved up until now.
Okay.
Most courts where the matters came up, issues were challenged on the grounds of jurisdiction.
Okay.
Who are you to question whether or not somebody had left the house or not?
Okay.
So the issue had not been resolved at all. Now, people forget also that the matter that is before the Supreme Court, if you look at the matter, you look at the relief sought by the parties.
Okay.
Apart from identifying the parties, what are the reliefs that the parties are seeking for the court? In other words, person can court, what they can find? Let me use local balance, right? Now, on the 29th of November 2023, Martins Chika Mehule, sitting in the position of Speaker of the House Assembly, filed a suit in the case of Rivers House Assembly and another against the National Assembly of Federal Republic of Nigeria and others, about 17 others. That suit had some fundamental reliefs that he sought.
Okay.
One was that we were seeking an order of the court to restrain INEC from conducting the by-election,
Okay.
right, into the House of Assembly to fill in the vacant seats. 2, he was seeking another restraining National Assembly from taking over the functions of House of Assembly of River State, right? 3, he was sending orders to restrain the governor and other defendants in that suit from taking certain steps. You remember that in your intro, you mentioned that the Assembly had a crisis on October 30th, right? So, as of that November 29, the issue of speakership, issue of defection, had arisen when they filed the suit.
Okay.
So when they filed the suit on December 11, when they defected on December 11, that became an issue.
We'll definitely get there because that's going to be one of the highlights of this.
From that point, it has been back and forth. The anger has been back and forth. If you want to question my legitimacy, what about this?
Exactly.
You want me to do this? Why should I do this when you are not? So until the issue of legitimacy was determined. So what happened that last month in Abuja for the Supreme Court was the governor's lawyers was, let me use the word smart enough, and that's the normal practice. Recall that the governor in that suit had withdrawn after the president's intervention. He had withdrawn his defense processes.
At the High Court.
Yes,
at the Federal High Court, yes. Before Justice Omotosho.
So when Omotosho gave his ruling on those relief sought and all that, it touched on the budget. But by December 13 of that year, the governor presented the budget to the House Assembly, presided over by Edson here as Speaker. After Justice Monmouth Anagogo's ruling, giving the veto to go ahead. Now, so he touched on the budget, which was not initially part of it. Right, we amended the
there was an additional.
So they brought in the budget. So he attacked the budget in his judgment. So the governor appealed. Now the appeal court held in that October judgment that you have waived the rights to defend yourself at the trial court, so it can't be heard here. So we're saying that all the appeal court found was the decision of Omotosho unchallenged. The governor having withdrawn, Edson he didn't even file anything. So the governor having withdrawn, there's no counter affidavit before. Just Omotosho to tell him this is why we cannot proceed. That's why we can proceed. The issues about
what's the implication? Because I was going to get to that.
Yes.
What's the implication of a party in a suit, particularly if you're the defendant, you withdraw your processes and probably inform the court you are no longer interested in the matter. Like you said, after the peace talk in Abuja, the governor went ahead to withdraw his own processes, meaning that he was no longer interested in continuing with that matter. Now, the Court of Appeal eventually, because Justice Omotosho gave his judgment on January 22nd, 2024, the governor withdrew on the 8th of January, 2024. So shortly after that, the judgment came. And of course, when there's a valid judgment, what it means is that it's only a higher court that can either invalidate it or uphold.
Yes.
So now that the governor withdrew, in the legal practice, what is the implication when a party decides not to continue to pursue a matter and willingly withdraws without any compulsion and then decides again to go back on appeal to challenge the judgment of that same court? Can you throw more light on that? Because
I wouldn't agree.
Beyond the issue of River State, there could also be similar challenges elsewhere. So people need to learn to understand the implication of some of these actions and inactions.
Yeah, I wouldn't agree that they withdrew without compulsion. You have referenced that on the 8th of January we withdrew.
Yeah.
Sequel to the meeting they had with the president.
Okay.
Now, if you look at that directive 1 was emphatic. The governor should withdraw all the process filed in court. Directive number 2, the House Assembly should withdraw all impeachment proceedings set up against him. Okay. And then on and on up to directive 8.
Yeah.
Now, the question I want to ask is, that was a political solution to the crisis. Of course, a political crisis.
It wasn't constitutional.
No, it wasn't.
Like many say.
Yeah, it was a political solution to the political crisis as for Assembly.
Okay.
Unfortunately, governor was not the proponent of that action by Ameule before Justice Omotosho. Okay. So maybe because it was not definite about him withdrawing, he did not withdraw. Now, the governor will feel hard done by. It's only human. So this was supposed to be set up.
Oh, really?
So naturally, he would look for means and ways to preserve himself, right? I'm sure he filed appeal, so I probably seek leave to be heard. This was not haven't withdrawn at trial court. But appeal court in this wisdom felt you're wasting our time. You have already waived your rights by withdrawing. We're not part of your politics, we're not interested, right? it is possible that at the Supreme Court level, the same thing would have happened. So the governor was advised to look at the issue that looks like these issues are live, these issues are not live. You can hold this one first. So once the issue of budget had come in, recall that after that judgment, an appeal got affirmed in October, another judgment came where Justice Joyce Ahmad Abdul Malik of the Federal Court, relying heavily on the Motosho's judgment, went out to redirect the governor to represent that budget.
So that's like three judgments.
Yeah, now,
2 from the Federal High
yes.
Court, 1 from the Court of Appeal.
Now, when that one came,
Yeah.
the governor appealed. Well, that one, they joined issues. They didn't withdraw. CBN was there. Most banks were there. The governor, they went all the way. As Malik handed that judgment, agreeing with them, taking the lead from Motosho.
Okay.
Now, when the appeal court held that the Federal Court has no jurisdiction, that judgment was delivered. That suit is captioned 1303.
Okay.
CS/ABJ/CV/1303/2023. It was delivered.
2023?
Yes. Delivered. So 2024 rather. Was delivered, I think, December 13,
Okay.
2024. Justice that bang or whatever they call him now, Booker. Now, it was of the firm view, he read the judgment that the Federal Court had no jurisdiction to go into questioning state laws.
Okay.
More so, a state budget. It's a State Appropriation Act. Only House of Assembly or a State High Court can't do that. Not the
Which
Federal
means
Court.
that even the assembly, the Martin Amehule-led assembly, could still go back to the State High Court to file that same
Yes,
suit.
yes.
Okay,
Now,
that's
so
right.
now that appeal is the last appeal. Now, in law, the last judgment of a court is the valid judgment. That's the judgment that stands.
Yeah, but let's get
So-
it clearer.
so the
no,
second
hold on.
judgment-
Let's get it clearer.
Yes.
Justice Abdul Malik
Yes.
was not dealing with the issues raised before Justice Omotosho. He was specific about funding,
Yes.
allocation,
The
money,
access to the Consolidated Revenue
access.
Fund.
Yes, that's
Yes.
like one out of the many prayers before Justice Omotosho.
Yes.
So we can't say in entirety that Justice Abdul Malik's judgment overrules that of Justice Omotosho.
No,
Of course,
I didn't say she
okay,
overruled.
okay.
No, I said she relied heavily
Okay.
on Justice Omoto's judgment. She made a lot of copious references
Yeah.
to his judgment.
Yeah.
That she is bound by it because she sits on the same bench with him.
Okay.
All right? So she agreed with him. Now, the appeal court, where the governor and his people went to file appeal, disagreed, said, all of what you referenced about the motion, you don't have jurisdiction to go into questioning state budgets or state
budgets,
laws.
yeah.
You can't. That's a province. Just like some people cite Section 252, sub 3, all right, of the Constitution and say, state high courts have no jurisdiction to question whether or not there's a vacancy in the House of Assembly of the state. Of course, that section of the law provides for determination of vacancy in office of governor or deputy governor or House of Assembly of the state, right? Some people have said it cannot question that of House of Assembly except the Federal High Court. Initially, it was not there. Now,
I think it was an amendment by either the
in the
7th
fourth,
Assembly
yeah, in
or
fourth
so.
alteration.
Yeah.
Now, my understanding is this. When it raised issues of membership of assembly, it has something to do with defection.
Okay.
So determining a vacancy in the House of Assembly has nothing to do with defection. They're two different things. Defection has to do with Section 109, sub 1G.
No. Let's get it here.
Yes.
You said it has nothing to do with defection,
Yes.
but in this case in point, particularly the one before Justice Obile, the guys, the honorable members, were talking about their legitimacy of the membership of the House based on the issue of defection, which means there's a vacant or there are vacant seats.
Yes.
27 seats.
Yes.
Because they were said to have defected.
Yes.
So what it means is that the defection thing, the vacancy thing are like two sides of a coin. Because if not for this so-called defection, the issue of vacancy will not arise.
Of course.
So I really want us to, deal with this issue of when you withdraw your processes at that stage. Can you go to a higher court? Because I saw some cases that were referenced and by the Court of Appeal in the judgment that I have here, where they also made, I think about 5 cases they cited, why you cannot withdraw at the lower court and then come back to the Court of Appeal and seek to be heard. I think that was actually the basis for the judgment that they gave. There were 3 judges in that panel and they all were in agreement.
Well, the reason is simply this. It's jurisprudential.
Okay.
Every court has no time to waste.
Oh.
So the thinking is that when you have the opportunity to be heard, take it. If for any reason you blow the opportunity, if you come back and you want to be heard, there must be substantial reasons why the court will hear you. Naturally, the court will hear you because the principle of natural justice provides for hearing the other party. The other party must have the principle of the altering party. My viewers, no vex. That means I will hear the other side of the story. No, hear only one side. That's what it simply means in Latin. The altering party. It's a fundamental provision of our constitution. It goes to the rule of natural justice. Before you shave a man's head, the man must be before you.
But the man refuses to be there.
No, I'm coming. It has a political background.
Okay.
Well, established that.
Okay.
The governor did not just willy-nilly on his own withdraw.
Okay, there was
He
compulsion.
withdrew as it were in deference to the president.
Okay.
Right? Okay. And even yesterday in Bayelsa, I made reference to that event that his heart was bleeding, etc. You know? But that's not for the story here now.
Yeah.
If a judge, in his wisdom, says, look, no matter how hard they cry, that you wave the right, I will not hear you. So be it. Matter went to the Supreme Court just before the matter was determined. Because the government had not withdrawn, this things we're talking about here would have been over.
Wow.
Because the Supreme Court has simply upheld that verdict. And don't forget that at the time the matter started, I made the point here, defection had not arisen. Now, if you file a suit in court and describe yourself as Chief Oby Ndukwe,
Yeah.
CEO of Beam Newspapers,
Yeah.
that's what name will go with all the way in.
Yeah.
So to have a process that is consistent.
Okay.
If tomorrow you wake up and resign from Beam Newspaper, but that matter is still in court, they'll still address you as such.
Okay.
They will not say former, no. Until somebody comes to the court to amend the processes.
Exactly.
All right, that's the name. So if a man files a suit that says, I am Martin Amegule, Speaker of Assembly, that's what it stands. So even when the effects, when the question comes and it's put through, that's what the court describes him. If Okojubo files and says, I'm Speaker, that's how the court describes him as.
At that time.
Do you understand? That's how these things work. So when a party that is before a court, for whatever reasons, withdraws, of what are consequences for that withdrawal?
Okay.
So those who probably had the political reasons for asking the government to withdraw probably had the reason why.
Okay.
What has happened? Have they also looked at the other flip side? Because the law is blind.
To
The law is blind to whatever
be-
is happening outside of the walls of the
yeah,
court.
exactly.
The goddess of justice, Hermes, is blindfolded. She has a skill on her left hand and a sword on the right
Sword on
hand.
the right hand.
She don't know who is before her. She cuts according to the weight of evidence, particularly in civil trials. So if the governor fails, I defer to the president. That's why I withdrew. And these other folks are using it against me. Probably that's why the matter is not resolved yet.
Okay. Okay. Well, I was going to go to the issue of defection, but I think you have also done good, on that matter. But I want to ask a question. I've heard you in some other media outings where you said I think section 109 is self-executory, is automatic, and is in line with the law and all that. Even though we also have a proviso which says, I think that should be subsection, is it 2? The one that empowers the speaker.
Yes. 109 sub 2.
Yes, to declare the seats vacant.
Yes.
After due consideration. If he finds it, yes, there's evidence that these people have defected, he would then announce it and declare their seats vacant. But you keep saying it's automatic. Now, why did the framers of the law include that subsection 2, giving that responsibility to the speaker? Yet, some persons insist that it is self-executory. Can you please...
It's not conflicting. It's straightforward.
Okay.
The speaker is part of the assembly. He presides over the assembly.
Okay.
So where there's a vacancy in breach of the constitution, that's 109 sub G, 109 sub 1 sub G, paragraph G, he, in 109 sub 2, gives effect.
He gives effect.
Yes. Now, that whole process has nothing to do with going to courts. Now, if a constitution had been, or a law had been enacted, all right, in the rules of interpretation, we have what they call the golden rule, we have what they call the mischief rule, we have what they call the literal rule. A judge is guided by these rules. When a judge has to interpret the statutes, he will look at what name to call what things.
Okay.
Now, if the mention of a particular compound of things or class of things is made in the statute, it excludes everything not in that class. So if the word says woman, girl, you cannot bring man, boy there. If the framer said, look, if you move from the party which you're elected
Yeah.
while the tenure is still on, that the party that sponsored the election did not
Not have issues.
go into an alliance with another party,
Yeah.
as in going to a merger.
Major.
3, there's no division in the party, crisis in the party. Out of those conditions,
Yeah.
if they are not present, you lose your seat. You shall, that's the language.
You shall.
You shall lose your seat.
Okay.
Now, the courts had gone ahead to interpret that to mean automatic vacation.
Okay.
Now, in law, again, we already said this. Under the common law jurisdiction,
Sorry, please. You said the court has interpreted
Yes.
that. Can
Yes.
you give us a particular case?
in the
where-
case of Ifeda Abegude against Honduras Assembly, Supreme Court had ruled on that defaction,
Okay.
on that section of the law, that where a party, a member of House of Assembly who is elected to House of Assembly leaves his seat in breach of any of these conditions, particularly this one about moving to another party. In the case of Ifeda Abegude, he left the PDP, left the Labour Party and joined PDP.
Okay.
So the court said you have lost your seat. Incidentally, that is the man who is the executive director, corporate services now in NDDC.
Okay.
That's how you feel that
Yeah.
Abegude, right? So that is the locus classicus. In other words, all of this argument about Section 109 sub G, rise and fall,
Yeah. So, but
on that judgment. And I'm coming, let me land on this point.
Okay.
In our system, once the Superior Court has made a pronouncement that is deemed the local classicus,
Yeah.
every judge down the ladder is bound by it. You can't review it.
Okay.
Even the Supreme Court, for the Supreme Court to return to review it, certain conditions must be met, and they are very, very difficult to meet.
Okay.
So the court does not blow hot and cold. If the court had not interpreted a section of the law, it's a different thing. Now, most people have asked, why is this matter dragging on for so long? From that December 11, 2023 to this date, a few state high courts are trying to go in there. But people have said, under Section 252 sub
Subsection
3,
three.
you cannot go there.
Yeah.
So the federal courts that have jurisdiction have not gone there.
Okay. So they
That
still
they-
need to.
You understand? So that when that happens and the matter is before a court, that's why in the subsequent suit that was filed by Mewul and Co.
Okay.
and the file affidavit and all that, they withdrew. Because staying there, just like same withdrew when he found that, look, he hurt me at Supreme Court. If party knows that, look, I've run myself into trouble, before judgment, you can withdraw. It's allowed. There's always a penalty for withdrawing.
There's no. Yeah.
There's always a penalty when you withdraw.
There's always a penalty.
Because you're wasting the time of other people who have joined issues with you. But if you know that, look, where I'm going to, a train is ahead of me, I could be crushed.
Okay.
I deserve to have a second life. I can pull out and pay the consequence that is less.
But of
devastating.
course, in this case, there's actually no judgment before their withdrawal. But in the case of SIM, we had a judgment. We had a judgment of the Federal High Court. I think that's actually where we have the difference.
I'm coming.
Yeah.
Don't forget,
Yeah.
as a lawyer, for instance, if I want to file for the rank of Senior Advocate of Nigeria, the rule says I'll file a number of suits that are done.
Okay.
Now, the language of the law is that this suit must be contentious. In other words, I cannot just go and bring one case. If I bring it's an ex parte motion, everything I got there was ex parte, everything is one side. No, that was not contended with.
Okay.
It must be a case that you had
Struggle.
a
There
brick
was-
bat.
Yeah.
The other lawyer came, you came, and then finally
argued, and then you
all
won.
of the facts came, all the evidence came, the judge now came with the determination of the issue.
Okay.
That is a judgment that is on the merits. Those are the kind of things we bring for the legal privileges committee to say, give me the rank of Senior Advocate, I'm qualified.
Okay. So what you're saying is that Justice Omotosho's judgment was not
No, it was not
determined
contested.
on merit.
No, there wasn't.
But it wasn't based on ex parte motions
No,
or ex parte orders.
it began by ex parte.
Yeah, but they elapsed.
I'm coming. After it lapsed, the
Yeah.
governor had been, the defendants have been served. The major principal defender that responded was the governor. I think it was 16th or 11th defender in that suit. I will pull out this counter affidavit. The counter affidavit says that, look, everything you have in affidavit, I don't agree with this, I don't agree with this. You pull that away, it's a one-way traffic. That's not defense.
But were you expecting the court not to give judgment because
No,
you withdrew?
the
No, I'm
court-
asking. I want
the dilemma-
those
dilemma
of
that can
us who
stop-
are not
yeah,
lawyers to
dilemma that can
understand
stop-
these issues.
The only part that can stop the court from giving judgment will
Judgment.
be the claimants coming to court to withdraw their suit.
Okay.
If the claimant did not withdraw their suit, then that means that if the counter affidavit had been withdrawn, that means what the claimant is asking for will be given.
Okay.
Whether or not the courts above will reason that way is a matter of conjecture. But what I've found across time is that if a party had an opportunity to file, and indeed filed,
Okay.
along the line you withdraw,
Okay.
if you come back to the people and say, I want to be heard, you must bring serious reasons to show why it should be heard.
Oh, good.
Otherwise, it can't be heard.
Okay.
For instance, I have a matter at the risk of bringing my client before you. I may not mention the client's name. I was called into that matter. I was briefed after the state high court had given the judgment. If I jump up, they executed if I was brought in. But I had to file an appeal. I had to seek leave to 5 hours out of time.
Okay.
Now, what we have done is to stop further execution of judgment.
Oh, okay.
Right? But we have to bring reasons sufficient enough
For the court.
appeal court that agreed that you have a case here.
Exactly.
I was not asking for the reliefs of judgment to us, dash. I was saying that we don't agree with this or I agree with those. These are the grounds for appeal. These are the particulars where it's agreeing with. And therefore, we want the court to grant us leave to appeal and then send us back to the High Court so we can contest.
Okay, but in all of all that you have said, it means that even the issue of vacancy will be decided by the Federal High Court.
Not necessarily. See,
No. Where there's a contention.
No, I'm coming.
Hold on. I'm coming. Let me frame the question better.
Yes.
Now, when there's a contention, and this, some persons say is self-executory, is automatic, and the people involved, affected, say, oh, it's not. What it means is that the other parties who say it is ought to go to Federal High Court, and then the court will determine and decide the matter.
Okay, let me say this for emphasis.
Okay.
Because you began by citing the matter before Justice Emmanuel Oby Ndukwe.
Okay.
I'll be mindful
Of.
not to make statements that are tantamount to sub judice or sounding prejudicial. I'll just be bound by what the court has said in Abengude's case, what the court has said in Abubakar versus AG Federation, what the court has said in I think a picture of cases. Our case, whatever, one of those cases, if I remember. About 4 cases had followed that same pattern. The courts have said they're bound by, once that fact is established, that you moved, and you're unable to show why you moved. Now, in some cases, what I've seen is that the presiding officer himself gets involved. For instance, in the case of Darie, Dapelam versus Darie, Plateau House Assembly has 24 seats. The first day, 13 members moved, including the deputy speaker, moved. The next day, the speaker himself moved. So 24 members had moved. 10 were now left. 10 now raised amongst themselves the speaker and proceeded against the governor to impeach him. The matter went all the way to the Supreme Court. And then below the Honorable Justice Walter Silvanus held that the House Assembly can sit because there's no breach Section 102 of the Constitution. The House Assembly can sit in the invalid numbers. At that point, nobody talks about Section 96 quorum. But the only thing you cannot do in circumstances to impeach the governor, you cannot do that. For you to impeach the governor, must be a full house. Full house of all constituents sitting and voting. Was the question of impeachment is a heavy thing, but you can do everything. 2, the same constitution says where there's a crisis in the House Assembly of a state and it cannot sit, National Assembly can take over the functions, can do everything but impeachment. So the issue of impeachment is sacrosanct, was a heavy thing. It does not even end with the House Assembly of a state. If you want to impeach the governor, it goes all the way to CJ. We'll start with a panel to look at
this case of the Pia Long, because it keeps coming like a recurring decimal. People keep quoting it, and not very many people are even aware of the issues. You know, I want to ask you a question. When the defection happened, the people who defected, both the speaker, the deputy, and how many of them? Is it 24 or 14?
14 defected.
Okay, good. When they defected...
From PDP to ACD.
Yes, when they defected, was there a suit in court?
No, there was no.
There was no
suit. It was when they made an attempt to impeach the governor that the matters went to court.
So you mean when they defected, they just left the State House of Assembly?
No, when they defected, the same thing happened in the university happened. A speaker emerged from those who did not defect.
Then what happened?
Who took charge.
Yeah, then what happened?
Now, those ones who stayed back are the ones that made an attempt to impeach the governor. That's how the matter now came to the province of the court.
Yeah.
So
it was heard in its entirety. Both the defection, impeachment.
Yeah, Darie came and said, you can't impeach me because the House doesn't have complete numbers.
Yeah.
Right? Now, all the way to Supreme Court held, the House can sit validly, whether numbers are complete or not in the circumstance. Those who defected, they lost their seats. All right? But this was a 2007 judgment. But they cannot impeach the governor until the House is fully seen. So the only is on INEC to fill the seats before you can go ahead and have impeachment. But that the numbers are depleted, no, you can sit.
But in this case of Rivers, I think there's a little bit a difference, you know, in the sense that those who are accused or who are said to have defected turned around and said, we didn't defect. We intended to defect, but we didn't defect. Now, we also have media banters where people talk about affidavits, that they swore to an oath, saying that they had defected. That was when the matter was before Justice Okorowo of the Federal High Court. And then, of course, before the matter could be heard, Justice Okorowo was elevated to the Court of Appeal, which means that the matter will be reassigned to the CJ. I mean, the file will go back to the CJ, who will reassign the matter to another judge. And I think it was reassigned to Justice Peter Lifu. And that's the one you were referring to, where they withdrew their case, because it was Martin Amehule and 26 others who actually filed, went to court,
1681.
asking the court to protect them, that they can't lose their seats because they attempted to defect or whatever. And so, on second thoughts...
No, they didn't say that. They stated the grounds for defection.
They stated what I mean is they stated the grounds for defection, but later on, from information which some of us also have, I don't know if you have it, they amended their affidavit. Well, we will still get to that. Please don't go away. Remember to follow us on YouTube and other social media handles. Subscribe, and so you can also get updates. Thank you.